Hello students, this is Dr. Rajmouli Amrishetty, practicing company secretary, corporate legal advisor and insolvency professional. Being insolvency professional and also author of a book on lectures on insolvency and bankruptcy laws, I am confident to properly present this topic and I am also glad to be part of this knowledge sharing mission. In this part of lesson, we will discuss about the pre-packaged insolvency resolution process, PPIRP, pertaining to micro, small and medium enterprises, which is called MSMEs, mainly covering the background for introducing PPIRP, basic features and who is eligible to opt for PPIRP, pre-initiation stage, filing application for initiation PPIRP, post initiation stage, approval of PPIRP or closure of PPIRP. First, let us cover background of PPIRP, that is pre-packaged insolvency resolution process. In fact, that in this 5 years since enactment, the IBC has brought about significant shift in credit and recovery behavior. It has aided in higher credit realizations and quicker recovery of business, thereby led for economic growth by freeing up capital in failed businesses and has changed the way the Indian society perceives business failures. As you know, the MSMEs stand in a different status when compared to other corporates. It is not an exaggeration to state these MSMEs are critical for India's economy and they contribute significantly to the GDP and provide employment to sizable population. The COVID-19 pandemic has impacted their businesses operations and exposed many of them to financial stress. The resolution of stress of MSMEs requires different treatment due to unique nature of their business and simpler corporate structure. Therefore, it was considered expedient to provide an efficient alternative insolvency resolution process under the code for corporate MSMEs, that is micro, small, medium enterprises, that ensures quicker, cost effective and value maximizing outcome for all the stakeholders in a manner which is least disruptive to the continuity of their business and which preserves jobs. The alternative insolvency resolution process for corporate persons classified as micro, small and medium enterprises was introduced by Insolvency and Bankruptcy Code Amendment Ordinance 2021 on 4th April 2021. Subsequently, it is passed by Parliament as Insolvency and Bankruptcy Code Amendment Act 2021, giving effect from the original ordinance date, that is 4th April 2021. Inter alia, through this amendment, a new chapter 3A containing section 54A to 54P was incorporated in IBC, containing the provisions regarding pre-packaged insolvency resolution process for MSMEs based on recommendations by the Insolvency Law Committee headed by Mr. M.S. Sahu, the then chairman of IBBI. Then let us understand the governing framework for this PPIRP. The provisions regarding PPIRP are governed under the Insolvency and Bankruptcy Code 2016 as amended by the Insolvency and Bankruptcy Amendment Act 2021. The Insolvency and Bankruptcy Pre-Packaged Resolution Process Rules 2021. The Insolvency and Bankruptcy Board of India Pre-Packaged Insolvency Resolution Process Regulation 2021. Then let us understand what are the basic features of PPIRP. This PPIRP is an alternate and voluntary mechanism with core elements of CIRP and it is time bound speedy resolution process. It also balances the creditor and debtor incentives, and it provides suitable safeguards to address debtor moral hazards, and it clearly defines the roles and responsibilities of key players, that is debtor, creditors, the resolution professional and the resolution applicant. Then let us understand who is eligible to opt for this PPIRP. A corporate debtor which is an MSME as defined under section 7 of MSME Development Act 2006 is eligible to apply for initiation of PPIRP if it has committed a default of at least 10 lakhs or more, and it is eligible to submit a resolution plan under section 29A of the code. It has not undergone a PPIRP during the preceding 3 years from the initiation date. It has not completed a CIRP during 3 years preceding the initiation date. It is not undergoing a CIRP, and it is not required to be liquidated by an order under section 33 of the IBC. If it satisfies all these features, it is eligible to make an application. And to evidence that the CD is an MSME, the application shall be accompanied by either a copy of the latest and updated Udayam registration certificate or proof of investment in plant and machinery or equipment and turnover as per notification 2119 in bracket E dated 26 June 2020 or of Ministry of MSME. That PPIRP envisages a hybrid process, that is pre-initiation stage and post-initiation stage. The pre-initiation phase is largely informal and post-initiation stage is formal. The informality at pre-initiation stage offers flexibility for the corporate debtor and its creditors to swiftly expose and negotiate the best way to resolve stress in the business, while the post-initiation stage drives value maximization and bestows the resolution plan with statutory protection. The following activities need to be undertaken in pre-initiation stage. Number 1, the corporate applicant intending to file application for initiation of PIRP shall convene meetings of the unrelated financial creditors, which is called as UFCs, that is financial creditors who are not related to parties of the CD, for seeking approval of creditors under section 54A, subsection 2, clause E and clause 3. Where the CD has no financial debt or where all the financial creditors are related parties, the applicant shall convene meetings of unrelated operational creditors, that is called as UOCs, and the unrelated operational creditors shall perform the same duties and functions as unrelated financial creditors. Lastly, for convening the meeting of UFCs, the applicant shall serve the notice of the meeting to UFCs at least 5 days before the date of the meeting, unless such shorter time is agreed to by all of them. The notice of the meeting shall indicate the date, time and venue of the meeting and specific agenda items for discussion. The applicant shall enclose a list of creditors and amount due to each of them in form P2, along with the notice convening the meeting, seeking approval for appointment of insolvency professional as resolution professional. In the meeting of UFCs, that is unrelated financial creditors, creditors having at least 10% of the value of the debt shall propose the name of an insolvency professional eligible under the regulations for appointment as resolution professional. The IP is eligible to be appointed as resolution professional if he and all partners and directors of insolvency professional entity of which he is a partner or a director or independent of the corporate debtor. A person is considered independent if he meets the requirement specified under regulation 7. The unrelated financial creditors representing not less than 66% in the value of the debt due to such creditors shall approve the appointment as a resolution professional and the terms of appointment in form P3. The terms of appointment shall include fee payable to the insolvency professional for performing duties in relation to pre-initiation phase under section 54B, expenses to be incurred by him for conducting PPIRP and expenses to be incurred by him in case management of the CD is vested with him under section 54J. The majority of the directors of corporate debtor shall make a declaration in form P6 stating that the CD shall file an application for initiation within a definitive time not exceeding 90 days, that the PPIRP is not being initiated to defraud the persons. C. The name of the IP approved by the creditors. The members of the CD shall pass a special resolution approving the filing of application for initiating PPIRP, along with the notice for convening the meeting seeking approval for filing of an application for initiating PPIRP. The applicant shall enclose a list of creditors and the amount due to each of them in form P2, declaration in form 6, the resolution of members referred to in section 54A subsection 2 clause G and the basic resolution plan. It is called as BRP. In the meeting of unrelated financial creditors, the creditors representing not less than 66% in value of the debt due to such creditors shall approve filing of application for initiation of PPIRP of the corporate debtor under section 54A subsection 3 in form P4. The IP, that is the IP proposed to be appointed as RP, shall ascertain the creditors in classes, if any, from the list of the creditors in form P2, identify 3 insolvency professional to act as authorized representatives, which we mean AR, means authorized representative, and obtain their consent in form P5, seek choice of creditors in the class, select the IP who is the choice of the highest number of the creditors in the class to act as AR, that is authorized representative, and inform the name of the IP along with his consent in form P5 to the applicant in accordance with regulation 15. The IP proposed to be appointed as RP shall prepare report in form P8 confirming if the CD is eligible for PPIRP and BRP, that is basic resolution form, conforms to the requirements. If the above process is completed, it is called pre-initiation stage. Application for initiation of PPIRP. After completion of the pre-initiation stage, a corporate applicant can file an application for initiation of PPIRP in form 1 in electronic form before the adjudicating authority, that is NCLT, National Company Law Tribunal, for initiating PPIRP. The application shall be accompanied by the following documents: A. Record of default. B. Consent of the IP proposed to be appointed as a RP in form P1. C. Approval of UFCs for initiation in form P4. D. Consent of insolvency professional proposed to act as AR, that is authorized representative, if any, in form P5. E. Declaration by directors in form P6. F. Members resolution. G. declaration by corporate debtor regarding avoidance transactions if any in form P7, H. report of resolution professional in form P8, I. audited financial statements of at least 2 financial years, J. provisional financial statements for current financial year made up to the date of declaration under section 54A class 2 subclass F, K. latest and updated Udayam registration certificate or proof that CD is an MSME, L. affidavit stating that the CD is eligible and not barred under section 29A of the code to submit resolution plan, M. a statement of affairs made up to date not earlier than 14 days from the date of application, N. a statement mentioning the names and addresses of the members of the CD with details of their respective shareholdings, O. proof of payment of application fee of rupees 15,000. P. The applicant shall serve a copy of the application for initiating PPIRP to the IBBI, that is Insolvency and Bankruptcy Board of India, before filing it with the NCLT, and proof of such service to IBBI to be enclosed along with the application, and Q. the document that records the authenticity or authority of the applicant to make the application, where the applicant is a member of the corporate debtor. Within 14 days of the receipt of the application, the NCLT shall admit the application if the application is complete or reject the same if incomplete. However, before rejecting the application, the adjudicating authority, that is NCLT, shall provide a period of 7 days notice to the applicant for rectifying the defects if any in the application. The adjudicating authority shall also deal with any application for initiation of CIRP pending for admission in accordance with the IBC while deciding on the application. The PPIRP shall commence on the date of admission of the application. The adjudicating authority on the PPIRP commencement date along with the order of the admission declare a moratorium under section 14 of the code and appoint the insolvency professional named in the application as resolution professional and cause a public announcement to be made by the resolution professional. The duties of the insolvency professional shall cease if the application is either not filed within the time specified in the declaration in form 6 or is not admitted by the adjudicating authority, that is NCLT. Now, let us discuss about the post initiation phase. The steps involved in the post initiation of PPIRP are as follows. The process is required to be completed within a time frame of 120 days from the PPIRP commencement date. The RP shall either file the resolution plan for approval or an application for termination of PPIRP with the NCLT within 90 days from the PPIRP commencement date. Now, during the PPIRP, the management of the affairs of the corporate debtor shall continue to vest in the board of directors of the CD, unlike in CIRP. The board of directors of the CD shall make every endeavor to protect and preserve the value of the property of the CD and manage its operations as a going concern, and the promoters, members, personnel and partners of the CD shall exercise and discharge their contractual or statutory rights and obligation in relation to corporate debtor. The CD, that is corporate debtor, shall within 2 days of PPIRP commencement date submit to the resolution professional updated list of claims along with the details of the respective creditors, their security interest guarantees in form P10 and preliminary information memorandum which is called PIM, containing information relevant for formulating a resolution plan. If any person sustains any loss or damage as a consequence of omission of any material information or inclusion of any misleading information in the list of claims or PIM, every person who is a promoter or a director of CD at the time of submission of list of claims or PIM, or has authorized submission of the list of claims or the PIM, shall be liable to pay compensation. Therefore, they ought to be very careful while declaring these things. Now, the CD shall submit base resolution plan, that is called BRP. BRP here we mean base resolution plan within 2 days of PPIRP commencement date. It may revise the BRP, that is basic resolution plan, if permitted by the COC. COC here we mean Committee of Creditors. The resolution professional shall make a public announcement in Form P9 within 2 days of the commencement of the process in the manner specified in Regulation 19. The resolution professional shall exercise and carry out duties as required under section 54F. It may be noted that the resolution professionals during the PPIRP is mostly supervisory in nature and not managing the CD like in a CIRP under the code. The resolution professionals have to work in coordination with the management of the company, that is corporate debtor, who continue to manage the CD, especially for collation of claims, preparation of information memorandum, that is IM. IM we mean information memorandum, reporting avoidance transactions and ensuring transparency and fairness of the entire process, safeguard stakeholders' interest and compliance with laws. Then, after submission of the form and completion of post initiation stage, then the question of approval of the resolution or rejection of resolution. If BRP, that is basic resolution plan, does not impair claims owed to operational creditors, the COC may approve it for submission to the adjudicating authority, that is National Company Law Tribunal. If the COC does not approve the BRP, that is basic resolution plan, or the BRP impairs the claims of the operational creditors, the resolution professional shall invite prospective resolution applicants to submit resolution plans to compete with BRP. He shall publish brief particulars of the invitation for resolution plan in Form P11 not later than 21 days from the PPIRP commencement date in accordance with Regulation 43. The invitation for resolution plan shall detail each step in the process and the manner and purposes of interaction between the resolution professional and the resolution applicant, along with corresponding timelines. It shall include the basis for evaluation, the basis for considering the resolution plan significantly better than another resolution plan, the tick size and the manner of improving a resolution plan. It shall not require any non-refundable deposit for submission of resolution plan. The resolution plans received in response to invitation and complying with the requirements of the code and the regulations shall be evaluated on the basis of evaluation. The resolution plan which gets the highest score shall be selected as best alternative plan, which is called BAP. We mean best alternate plan in competition with the BRP, that is basic resolution plan. The COC may consider BRP for approval if no resolution plan is received. The COC may consider BAP if for approval if it is significantly better than BRP. If it does not approve a significantly better BIP, the process terminates. If the BIP is not significantly better than BRP, the RP shall disclose the scores of BIP and BRP to submitters of these plans and invite them to improve their plans in accordance with regulation 48. The process of improvement shall continue till either of the submitters fails to use the option within the specified time. The resolution plan having higher score on completion of process of improvement shall be considered by the COC for approval. If the COC does not approve it, the process terminates. Closure of PPIRP after completion of the above processes when the PPIRP closes is discussed here. The PPIRP closes in the following circumstances. Number 1, on approval of either BRP or BAP by the adjudicating authority, that is NCLT. 2, on expiry of the 90 days if no resolution plan is submitted to the adjudicating authority, that is NCLT for approval. 3, the rejection of the resolution plan by the adjudicating authority. 4, on approval by the adjudicating authority of the application filed by the resolution professional for termination of PPIRP, where the COC approves termination with the 66% of voting share. 5, on conversion into CIRP based on the application filed by the resolution professional, where the COC approves, so with 66% of voting share and the CD is eligible for CIRP. The RP of the PPIRP is appointed as IRP of the CIRP. 6, on an order of termination in case either no resolution plan is approved by COC or the resolution plan approved by the COC does not result in change in management, where the adjudicating authority has vested the management of the CD with the resolution plan under section 54J. Thank you, students. In the next lesson, we will discuss about the provisions regarding insolvency and bankruptcy process for individuals and partnership firms. Though the part 3 of the IBC covering the insolvency of and bankruptcy of individuals is not enforced, yet this part becomes inevitable and important to be discussed. Therefore, we will discuss this part in the next class. Thank you.